Sorry, can you all hear me well, actually?
Yeah, we can. Can
Okay,
you
can.
hear us?
Yes,
Okay.
anytime you are ready.
Good afternoon, members of the panel. My name is Austin Seah, and I'll be speaking on behalf of the first appellant, Mr. Landert, on the first issue regarding GDC's quorum and a fourth issue on doping. My co-counsel, Mr. Mark Peter, will be speaking on behalf of the second appellant, Ms. Tangs, and will address issue 2 on the location of the tribunal and issue 3 on Ms. Tangs' admissibility for 14 minutes. We respectfully reserve 1 minute for a rebuttal. Members of the panel, this case concerns ensuring fairness and addressing the issues of potential biasness. The gold medal belongs to Mr. Landert, who earned it through his performance leading his team's comeback in the finals of the qualifying games. However, the tribunal that reviewed the matter appeared to have a majority inclined towards Ms. Tangs. Given these circumstances, the law supports the medal's return. Failing to do so could undermine the protections and fairness that athletes are entitled to. With that, I make two submissions regarding the first and fourth issue. Firstly, the Games Disciplinary Committee, hereinafter the GDC, was biased in coming to a decision. Mr. Douglas and Ms. Farina are not independent and impartial arbitrators of the GDC's quorum. Secondly, the GDC had erred in finding that Mr. Landert had been liable for doping. Bluebet is not inside the WADA list, the World Anti-Doping List, and Mr. Landert is hence not liable for doping. Turning to the first issue, to determine the criteria of an arbitrator, the applicable rule is from the CAS-related arbitration. Hereinafter, as Rule 33 states, and I quote, every arbitrator shall be and remain impartial and independent to the parties and shall immediately disclose any circumstances which may affect his or her independence with respect to any of the parties. This proposition is found in Malaysia's Arbitration Act under Section 13(8) Part B, which reads, and I quote, in appointing an arbitrator, the director of the Asian International Arbitration Center or the High Court, as the case may be, shall have due regard to other considerations that are likely to secure the appointment of an independent and impartial arbitrator. As noted in both the wording of Rule 33 of the CAS Code and Section 13(8) Part B of the Malaysian Arbitration Act, the criteria of an arbitrator requires both impartiality and independence. As long as one of these criteria are not met, this would demonstrate that an arbitrator is biased. Turning to the lack of independence, to determine what amounts to an independent arbitrator, we can look to case law. In the 2006 CAS case of
Sorry, counsel, before you go on to that, can you just give me a very brief definition of what you think is the difference between independence and impartiality?
Certainly, Mr. Arbitrator. With regards to independence, it relates to a lack of relations with a party that might influence an arbitrator's decision. With regards to impartiality, it directly concerns the absence of a bias or predisposition towards one of the other parties, and this separation can be found inside the CAS code.
So are you saying that on the facts of this case, the arbitrators are both not independent and not partial or not impartial?
Uh, with regards to the case itself, we are submitting that there's a lack of independence on parts of the arbitrators. Essentially, arbitrator must both be independent and impartial. And as long as one of these criteria are not met, you'll find that the arbitrator is biased.
So you're saying all the arbitrators are not independent and not partial or not impartial.
Yes, Mr. Arbitrator.
Okay,
Sorry,
okay.
not all of them. Specifically, only Mr. Douglas and Miss Farina in our
All right,
case.
all right.
Turning now to case law. In the 2006 CAS case of FCZ and NF at paragraph 5, the court noted that strong or negative emotional bonds through relations between the arbitrator and one of its party or counsel may indicate a lack of independence. This proposition is similarly held in a 2000 Swiss Federal Tribunal case of Sadi Senna Constructions at para 3. Turning first to Miss Farina, there are two types of relationships that she has with Miss Tangs. As seen from para 4 of the record, she is Miss Tang's cousin sister, showing that Miss Farina has a familial connection to Miss Tangs. Essentially, Miss Tangs is Miss Farina's cousin. showing a personal relationship between both parties. This kind of personal connection could easily be characterized as a strong emotional bond between family members, which can indicate an impartiality on the part of an arbitrator. At para 4 of the record, Ms. Farina was also seen to provide extra on the side coaching to Ms. Tang's team and prepared them for the upcoming qualifying games. This
Also,
demonstrates
can you bring me to the particular paragraph you're citing?
para 4 of the record, Mr. Arbitrator.
So the record at paragraph 4, is there a
Yes.
particular page for it?
It's apparently the record isn't paginated, but it's between page 2 and page 3 of the record.
So paragraph 4.
Paragraph 4, Mr. Arbitrator.
I see. And you're saying Miss Farina is Miss Tang's cousin sister. What does it mean?
Essentially, we are showing that there's a familial relationship between Miss Tangs and Miss Farina by the virtue of the word cousin sister, which essentially just means a cousin. That means there is a familial relationship between an arbitrator and
So
one
is
of
it a cousin or a sister?
cousin sister, her cousin sister,
A cousin's sister.
cousin sister, which is,
I
if
see.
you look at the
Okay.
family tree, it's basically your cousin.
I mean, then we would have a follow-up question, right? How close does the relationship have to be? Because if we are talking about, for example, the Companies Act,
Yeah.
okay, in terms of directors, when you say that somebody is a relative of a company director, usually it doesn't extend to cousins. Usually it doesn't.
Hmm.
So why should, so can you cite me some cases for that threshold, or do you have that basically?
Unfortunately, Mr. Arbitrator, I do not have specific cases that directly states that a cousin would amount to this threshold, but it's simply an inference we are making on the rule of the case. And if Mr. Arbitrator isn't with me on this point,
And
there
I'm not
is
saying that I'm
another
not with
rule
you. I'm not
that
saying I'm
is
not with you, but yeah, continue, please.
um actually there's a much lower threshold that simply that there must be a relationship between the parties. Rather, it
Oh,
suffices that an arbitrator, based on the circumstances relating to the arbitration, to be objectively viewed as an arbitrator which lacks independence. And this proposition is laid out at paragraph 7.4 in the 2020 Swiss Federal Tribunal case of Sanyang and World Anti-Doping Agency. And this proposition is further enforced in the IBA Guidelines of Conflict of Interest in International Arbitration at Section 2B, where the relevant portion reads, and I quote, from the view of a reasonable third person having knowledge of the relevant facts and circumstances which would give rise to doubts as to the arbitrator's impartiality or independence. While it is noted that such guidelines are not binding, they still have been noted to have an impactful influence on the practice of arbitration institutes and the courts. Turning to the application of such principles to our case, we acknowledge that there's no evidence of any actual bias or demonstrated by Mr. Douglas or Ms. Farina, as rightfully pointed out by you, Mr. Arbitrator. However, the necessary inference is that there's biasness arising from the objective, reasonable third party. As seen from para 26 of the record, the GDC's quorum is a tribunal operating on a two-thirds majority, of which two of them maintains personal documented familial or professional bonds with Ms. Tangs, the party contesting the results. They cannot objectively be viewed as independent in its adverse ruling against Mr. Landert, as seen at para 33 of the record. Simply put, the presence of a familial relationship between Ms. Tangs and Ms. Farina, coupled with a close extended personal relationship between Mr. Douglas and Ms. Tangs, as seen from para from para 26 of the record, is sufficient for a reasonable third party to ascertain their lack of independence. And in conclusion, we submit that Ms. Farina and Mr. Douglas are biased members of the GDC's quorum. Turning now to the second issue regarding the doping.
sorry, Counsel, before you go there, I recall that the prayer was, or the issue that was framed was whether the GDC's quorum had been biased in a decision, coming to a decision due to Mr. Douglas and Ms. Farina's position. Wouldn't the issue be to show how Mr. Douglas and Ms. Farina had, in the grounds of the decision itself, showed some bias rather than pointing to all these extraneous factors to say that they are biased?
understand your concern, Mr. Arbitrator. We do acknowledge that on the record itself, there's no obvious facts of the arbitrators showing any form of biasness. However, as the rule has clearly been stated and has been emphasized throughout all practices of arbitration, it suffices that based on the facts, all it needs is that a single person or objective third party would be, given the facts of the case, would ascertain that the arbitrator is biased. It
O-
doesn't need to
Okay,
be.
then what about the fact that the tribunal, the GDC tribunal, actually interpreted the rules on Miss Tang's, I think I quote you, you said admissibility, right?
Yes.
Uh, as as that she had to be 100% Asian. Would that be something which is evidence of the GDC's quorum being biased in coming to a decision?
I can understand the point of view of that, Mr. Arbitrator, but we do note that they actually ruled against Ms. Tangs, but a finding of liability of Ms. Tangs doesn't mean that they were not inherently biased against Mr. Landed, as they also ruled against him. To show that they was truly biased against Ms. Tangs, it would be more likely that they didn't rule against her and they ruled against Mr. Landed.
Okay, okay.
I note my time, Mr. Arbitrator, and I will briefly summarize my submissions on the fourth issue. Firstly, Rule 12 of the qualifying game rules should not have been applied, as it is overly broad and inconsistent with the WADA code. And notably, the WADA code is the exclusive standard for doping violations. As noted at Rule 7 of the qualifying game rules, and I quote, it has to be an occurrence of one or more of the anti-doping rule violations set out in the WADA prohibited list and the WADA code. And Rule 13 of the qualifying game rules that also notes that, and I quote, referring the athletes to the WADA prohibited list for the list of prohibited substances. Accordingly, this shows that the WADA code forms the exclusive and mandatory benchmark for determining anti-doping violations, mirroring the structure of Olympic Article Charter Rule 44, which makes adherence to the WADA code obligatory for the IOC.
Sorry, what is Rule 44 of the Olympic Charter, is it, you're saying?
Yeah, Olympic Charter essentially states that the WADA code will be the exclusive and mandatory benchmark for finding of an anti-doping violation. And we understand the concern is that essentially the GDC has found Mr. Leonard's liability on the basis of Rule 12. However, Rule 12 is inconsistent and ultra various. Rule 12 defines a prohibited substance as any substance or method contrary to the spirit of the sport. This is clearly a broad definition, and crucially, the CAS has rejected such broad provisions. In the 2004 CAS case of Maria Louis Kelly Williams and IOC, the panel noted that a catch-all provision of, and I quote, other chemical substances with similar chemical nature, end quote, cannot be construed to mean every stimulant, which is precisely what Rule 12 of the qualifying games seek to do. At para 25 of that case, it was noted that such an interpretation would not pass the test of clarity and predictability. They further brought in examples of other stimulants such as nicotine and caffeine, which all fall under the interpretation of Rule 12, and yet they are not banned by the CAS. Therefore, an extremely restrictive approach must be taken in interpreting Rule 12, which should be read together with the WADA guidelines, and is precisely what Rule 13 has provided for in the qualifying game rules.
Sorry, your submission is that the rule should be interpreted in a certain way and not that the rule itself should be ultra virus or what? Or are you saying in alternative? What is
No,
your primary position?
my primary position is that Rule 12 in itself is ultra virus if we apply it solely. However,
Okay.
if you read it together with the WADA code, it wouldn't be ultra virus. But the fact that the GDC has found liability on Mr. Lander solely on Rule 12 makes it ultra virus. And essentially, CAS jurisprudence confirms that sporting bodies cannot expand doping rules. In the 2011 CAS case of USOC and IOC, the IOC's attempt to impose additional sanctions beyond the WADA code was held invalid because the Olympic Charter had already made the code mandatory and the only provision where a doping violation could be found. Therefore, Rule 12 of the qualifying game rules should not be followed, and a finding of a doping violation under GDC's own rules is ultra virus and should not be followed. I note my time, and unless there may be a further assistance on the issue.
No, no, thank you.
Thank you, Mr. Arbitrator. I'll hand over my time now to my co-counsel, Mr. Mark Maxwell Peter, who will address the remaining two issues. Thank you.
Mr. President, members of the tribunal, as introduced earlier, my name is Mark Peter, appearing on behalf of the appellant, Ms. Tanks. I will address two issues in this hearing. First, the first issue concerns whether the GDC erred in convening the disciplinary tribunal in South Lankaland. Mr. President, I will structure my submissions in two different parts. First, the legal frameworks, namely the Malaysian Arbitration Act 2005 and the qualifying game rules. And second, the relevant authorities and how they apply to the record before this tribunal to demonstrate why the tribunal held in South Nangkalan cannot stand. Mr. President, the governing law for this arbitration is Malaysian law, as clarified in paragraph 42 of the clarifications. The section 22 of the Malaysian Arbitration Acts provides, and I quote, where the parties fail to agree, the seat shall be determined having regard to the circumstances of the case, including the convenience of the parties. This embodies the principle of procedural fairness, that the chosen venue must not prejudice either side. In addition...
Sorry, why are you talking about seat when we are talking about location? Aren't these two different things?
Mr. President, I'm here mentioning that the Games Discipline Tribunal erred in convening the tribunal in South Nangkalan, and we are trying to shine light on the fact that the Malaysian Arbitration Act and the Rule 23 of subsection 1 of the qualifying games itself holds that the internal tribunal be convened in a country where the tribunal was held, but in reality, according to the records, the tribunal was in the end held in, instead of being held in Rambutana, it was held in South Nangkalan.
Sorry, what does the article you're referring to in the Malaysian Arbitration Act read? How does it read?
Mr. President, as the section 22 of the Malaysian Arbitration Act, quote, and I quote, it reads as, where the parties fail to agree, the seat shall be determined having regard to the circumstances of the case, including the convenience of the parties.
So my point is this, it specifically mentions seat. Does
Right.
Rule 23 of the qualifying games rule mention anything about a seat?
Yes, Mr. President. In the qualifying game rules, it specifically says where upon hearing, as soon as possible in the country where it is practicable to do so. So going further into the argument.
No. So does Rule 23 explicitly state the word seat?
No, Mr. President, it does not. But we are trying to consider an argument where we are trying to explain that it was the seat which was changed by the GDC itself was not done the seat was not the athletes are not giving the consent to change the tribunal seat to South Lanka, and the GDC on its own moved the tribunal to
Counsel, I'm not so sure that you understand what the distinction between a seat and a venue or / location is. The point of having a seat in any arbitration is so that the arbitration can be governed by the rules of the seat. So for example, here we are talking about Malaysia, right? As the seat. Malaysia is the seat. It is the governing law. So we apply the Malaysian Arbitration Act in terms of any procedural rules or law for this arbitration. Okay? This is not the same as the location of where the arbitration is to be held. You can have a seat of this arbitration in Malaysia, but you can have the venue in Nangkalan or whatsoever it is. So I don't see why the arguments of seat should be brought in this way. I think you need to be clear about that. That's the first point. But anyways, please proceed with your other arguments on why we are saying that the tribunal being set up in Guava Land is an error on the GDC's part.
Thank you, Mr. President. As the record shows at paragraph 29, the riots in Rambutana subsided within 3 days, and the tribunal was established 1 week later. It was therefore practicable to hold the hearing in Rambutana itself, as the rules require, by relocating the tribunal in
Sorry,
South.
you said 39 where?
Uh, Paragraph 29, Mr. President.
Oh, 29. Okay, go on.
By relocating the tribunal to South Nagaland, which houses the Federation's administrative office, the GDC disregarded both Section 22 of the Malaysian Act and Rule 23 of the qualifying game rules.
I'm not so sure you can still say that after what I said, you can still say that you can still base your argument on the Malaysian Arbitration Act, but please go on.
Mr. President, this interpretation also aligns with the federal court's decision of R. Ramachandra and Industrial Court of Malaysia in paragraph 1, where the courts held that the decision tainted by procedural unfairness or bias is invalid. Accordingly, the GDC's relocation of the tribunal contravened not only with the domestic legal framework, but also the overarching principles of lex sportiva, which demands that the disciplinary bodies act impartially and avoid even the appearance of home court advantage.
So I'm assuming that you're relying on that Malaysian case for the proposition of unfairness, right? Procedural unfairness.
Yes, Mr. President.
But can you cite me a case which would be analogous to the current situation, or any cases which give me some sense of, the fact that the facts of this case right here would amount to procedural unfairness? Because without similar cases which I can be guided by, it's very hard for me to decide,
Yes, Mr. President. I apologize, but I will not be able to provide you the analogous case at this point in time, and I would like to defer to the written submissions.
But your written submissions are quite scarce in the first place.
Yes, Mr. President. I would like to rely on my further written submissions and revert back to you on this matter.
Okay.
Mr. President, in the 2018 case of the Muthu and Peshin, on paragraph 139 to 143, the ECHR explained that the impartiality must satisfy both a subjective and an objective test, namely whether the reasonable observer would perceive this tribunal as independent. Applying these principles here, seating the tribunal in South Nagaland creates an appearance of partiality because, firstly, the GDC is institutionally tied with the organizing structure of the global games. Second, the local law, administrative staff, and the facility belongs to the same federation overseeing the disciplinary proceedings. And lastly, the procedural familiarity and the logistical advantages favor the respondent, placing the athletes at disadvantage.
Sorry, you sound like you're relying on that case for similar facts. Are you?
The procedural facts, Mr. President, not the factual matrix of the case.
Okay, but if you're talking about procedure, then you are citing me a ECHR case. How is that relevant to Malaysia?
Yes, Mr. President. We do know that the case itself was decided in the ECHR, but it is important to note that the case of Muthu Peshin the athletes went to the CS proceedings before appealing under Article 6, subsection 1 of the ECHR, where they alleged that the denial of fair trial. The decision thus arises directly from the CAS framework and is highly persuasive in this matter.
I'm not sure whether it's highly persuasive, but go on.
Yes, Mr. President. Moving on, in the CS case of SC Sporting Club and Lujubin Kovic, on paragraph 33 to 39, the CS panel reaffirmed that only an independent arbitration tribunal guaranteeing fair proceedings and equal representation of both sides qualifies as a legitimate forum under Article 22B of the FIFA regulations.
Sorry, so what year is this case and what are the facts of the case?
President, the case is a CS case from 2010, and the facts of the case is that the panel I would like to defer to further written submissions, Mr. President.
Again, okay lah.
Mr. President, so the panel in this case concluded that the Romanian Professional Football League Tribunal, whose members were appointed solely by the league's executive committee, could not be regarded as independent. And therefore, this case establishes that even structural or institutional ties without the proof of subjective biasness are sufficient to undermine the appearance of impartiality. Mr. President, for these very reasons, the appellant submits that the GDC's internal tribunal was improperly convened in South Nangkalan. We therefore ask that the decision to be annulled and the matter remitted.
Remitted to where, sorry?
And the matter remitted to the tribunal convened in a neutral forum in accordance with the Malaysian Arbitration Act and the principles of Lex Sportiva.
But why can't this panel decide on the merits of the issue or merits of the case? Don't we have like a de novo review powers?
Yes, Mr. President, we do. So the panel
we do. You do.
You do.
Okay.
The panel.
What was the legal basis for that?
As a panel itself is truly the only neutral seat that guarantees independence, transparency, and the legal.
I'm asking for the provision of the CAS code, if that helps.
Yes, Mr. President. Mr. President, I would like to defer to my further written submissions at this point. Moving on to the second issue. The next issue relates to whether the GDC erred in declaring Ms. Tanks ineligible to participate in the qualifying games. We submit that the GDC acted ultra-virus and in violation to both the qualifying game rules and Lex Sportiva. The GDC misinterpreted Rule 3 of the qualifying game rules, rewriting the standard of eligibility to require 100% Asian citizenship, thereby acting discriminatorily and beyond its powers. Rule 3 subsection 1 provides that a person is eligible to be participating athlete if he or she is a citizen or a permanent resident of a country in Asia. There is no mention of exclusive or 100% Asian citizenship. By its plain meaning, the rule adopts an inclusive standard based on citizenship or residence and not a restrictive test of purity of nationality. Any attempts by the GDC to narrow down this rule departs from the very text and violates the principles of legality and fairness under Lex Sportiva. As the record shows on paragraph 33B, the GDC held that Ms. Tanks was...
Which page, sorry?
Paragraph 33, subsection B, Mr. President. The GDC held that Ms. Tanks was not 100% an Asian citizen and therefore ineligible to participate. However, that additional requirement does not exist in the rules. In doing so, the GDC exceeded its interpretive power and acted as a rule maker rather than rule interpreter. In the 2008 CAS case of ANS and Norwegian Wrestling Federation on paragraph 18, the panel held that where rules are ambiguous, they must be interpreted contra proferentum, which means against the drafting body, which usually is the sporting federation. Similarly, in the 1991 CAS case of G and FEI para 7, the panel reiterated that the unclear regulations must not prejudice athletes who rely on the published text. Applying these principles, any doubt in Rule 3 must be construed in the favor of the athletes and not against her. Mr. President, Mr. President, both the issues strike at the heart of Mr. President. Ms. Tanks lawfully meets the eligibility requirement under Rule 3, subsection 1. She is a recognized citizen of the Asian state Durrania and has never represented another country and was entitled under the Olympic Charter to elect her allegiance.
Can I see that on the record?
Paragraph 32 of the record, Mr. President.
Okay.
Uh, by imposing an additional and discriminatory condition of 100% citizenship, the GDC acted ultra-virus. So, Mr. President, to conclude both the issues, first, on the tribunal's constitution, the GDC's decision to convene proceeding in South Nagaland, its own headquarters, undermined neutrality and procedural fairness. And on the second, on eligibility, the GDC exceeded its authority by rewriting Rule 3 to require 100% Asian citizenship. Accordingly, we respectfully pray that the tribunal allow both the issues, declare South Nagaland invalid, and affirm Ms. Tang's eligibility, thereby restoring fairness, neutrality, and integrity owed to all athletes. Now, now I will hand my time to the respondent.
Oh, not yet, not yet. Counsel, I do have some questions.
Thank
You and your co-counsel keep saying what things are ultra virus. What do you mean by ultra virus?
I can step in on this point, Mr. Arbitrator.
No, I would like I think Mr. Mark
Mr.
to
President,
answer that.
ultra-virus in this scenario means that it was acted beyond the powers of the authority. It's in this case. So, for example, in the case what we are trying to imply is that GDC went beyond its acting powers, which were not gazetted to the GDC's tribunal in the first place. For example, where GDC was only supposed to interpret the rules, they tried to rewrite the rules. That could be that could be summarized as GDC acted ultra vires, which also means beyond its powers.
Okay. Yep, that's all. Thank you.
Thank you, Mr. President. I will now hand my time over to the respondent.
Thank you.
Mr. Arbitrator, if you are ready.
Yep.
Good afternoon, Mr. Arbitrator. My name is Seah, and I'll be speaking on behalf of the respondent, the Games Disciplinary Committee, hereinafter the GDC, on the first issue regarding the GDC's quorum and a fourth issue on doping, which are Mr. Lander's issues on appeal for 14 minutes. My co-counsel, Mr. Brendan Zhang, will be speaking on issue 2 on the location of the tribunal and issue 3 on Ms. Tang's admissibility, addressing Ms. Tang's issue on appeal for 15 minutes. We respectfully reserve 1 minute for rebuttal. Mr. President, this case is not about sympathy for one athlete or the popularity of another. It is about upholding the rules of and integrity of the qualifying games. The GDC acted within its mandate, applying the governing rules and principles to protect fair competition and to ensure that the games are conducted without illegality or undue advantage. With that, I make 2 submissions regarding Mr. Lander's claims. Firstly, the GDC's quorum was not biased in coming to a decision, as both Ms. Farina and Mr. Douglas are independent and impartial arbitrators. Secondly, the GDC did not err in finding that Mr. Lander has been liable for doping. Blue Bat, in its nature, is a performance-enhancing drug. Turning to issue 1, while the appellant may seek to rely on Rule 33, this is incorrect. What Mr. Lander intends to do is to challenge an arbitrator as seen from para 37 of the record. To determine if an arbitrator should be challenged, the applicable rule instead should be Rule 34 from the CAS-related arbitration, hereinafter the CAS Code. Rule 34 states, and I quote, "An arbitrator may be challenged if the circumstances give rise to legitimate doubts over his or her independence or impartiality." This threshold of legitimate doubt can be found in wording of the Malaysian Arbitration Act at Section 14.3, Part A, and is similarly upheld in Article 180, Part 1C of the Swiss Federal Act on Private International Law, hereinafter the PILA.
Why is Swiss law applicable here? I prefer very much the Malaysian case you just cited.
Certainly, Mr. Arbitrator, even if we do not rely on the Swiss Arbitration Act, both the CAS Code and the Malaysian Arbitration Act, as seen from Section 14.3 Part A, both emphasize there must be legitimate doubt. And essentially,
So is there a Malaysian case which defines what legitimate doubt is?
Uh, unfortunately, Mr. President, I do not have such a case with me on hand. However, I can provide you with a 2020 Swiss Federal Tribunal case of Sanyang and World Anti-Doping Agency, where the courts noted at paragraph 6.5 that there must be concrete facts objectively giving rise to the lack of dependence. And
Okay,
turning,
your opposing counsel earlier referred to the same case of Sanyang, right? So what's the difference between how he's using it and how you're using it?
in their respect, Mr. President, the opposing counsel seek to use Sanyang on the fact that that it suffices that their arbitrator may be seen by third party to be construed as a arbitrator that lacks independence. While in our case, we are also illustrating the fact that similarly in that case, they noted there still must be a high threshold of concrete facts. And this is the rule that appellant has conveniently failed to mention. And in our
I
case,
see.
we submit that there are no concrete facts of a lack of biasness. Turning to para 4 of the record, Miss Farina is described merely as Miss Tang's cousin sister. While this indicates a blood relation, it's a relatively distant one, and there's no evidence in the record that suggests that there's any meaningful personal or emotional closeness between them.
I'm sorry, do you say that they are blood related?
Uh, by virtue of the fact that they're familial connections and that a cousin is more often than not blood related
But
to
she could be adopted, no?
um Mr. Arbitrator, this doesn't impact our case in any way. In fact, it further strengthens it. It can be seen that they are not blood related, which shows the distance between the families. And ultimately, there's no evidence going to show any of their closeness as as the appellant has seek to rely on. The absence of any indication of frequent interaction, shared household, or personal involvement beyond this supposed genealogical link, as Mr. Arbitrator has rightfully pointed out, shows that their relationship is more nominal than substantive. Moreover, although the record at para 4 shows that Ms. Farina had provided some on-the-side coaching, this should be viewed as a limited and informal engagement. There's no suggestion that she held a permanent coaching position or received remuneration.
But doesn't that point to an appearance of bias already?
Mr. President, we are relying on the threshold of legitimate doubt. And in this
Okay.
case, some side coaching can just simply be seen as somebody who is just helping you. It doesn't show that Miss Farina was Miss Tang's like long-time coach or essentially helped her for since she started playing Quidot. Essentially, it doesn't show an entrenched professional association that will compromise her ability to be impartial. It is plausible that Miss Farina's involvement was situational, incidental, and peripheral to Miss Tang's competitive endeavors. Turning now to Mr. Douglas, the professional interactions such as the fan meetups, as seen from para 26 of the record, where both Mr. Douglas and Miss Tang were spotted together, are typical of public figures in the esports realm and do not indicate a privileged or adversarial relationship that will compromise his judicial capacity. The one-time special and personal sharing session, which the appellant seeks to rely on, was an event that took place 6 months prior to the tournament, as seen from para 26 of the record. A single historical event does not establish an ongoing dependent relationship that will necessarily sway his judgment regarding the complex legal issues of doping or eligibility. Unless there are further questions on the first issue, I'll turn to the second issue regarding doping. We submit that the GDC did not err in law. Our submission has two main arguments. Firstly, the GDC acted within its jurisdiction in finding that Mr. Landert committed a doping violation under Rule 12 of the qualifying game rules, hereinafter the QGR. Secondly, the GDC's decision was consistent with CAS jurisprudence and Lex Spordivia principles. Turning to our first argument, as noted in Rule 12 of the qualifying game rules, it states that, and I quote, It defines a prohibited substance as any substance or method contrary to the spirit of the sport.
So
This
what is contrary to the spirit of the sport? Can you define it for me?
certainly, Mr. Arbitrator, as noted in the WADA Code at page 13, the spirit of the sport is the celebration of the human spirit, body, and mind. It is the essence of Olympism and is reflected in the values that we find through sport, including the value of excellence in performance. And excellence in performance is precisely what we are contending here. Putting it in the context of Kidok, it is essentially an e-sport where concentration and focus is the key to winning. This is something that Mr. Lander knows very well, with himself coming clutch in draw-breaking games, as seen from para 6 of the record. As seen from para 12 of the record, the final match between himself and Miss Tangs, such a close game involves is extremely close and is extremely tiring on both the eyes and mind. Therefore, a player who deserves to win is one who is able to, without any doping or other form of assistance, focus all the way to the end. However, Mr. Lander was only able to win with the assistance of Bluebat. Knowing that Bluebat could keep his energy up, he kept them nearby as seen from para 12 of the record. Miss Tanks, with a dominant performance as seen from para 11 of the record, was bound to have won that tournament, if not for Mr. Lander's intervention with 5 points. This concentration enhancing drug essentially allowed Mr. Lander to take the edge over Miss Tanks as seen from para 13 of the record. Therefore, his actions go against the core of rewarding a player's excellence in performance, which is against the spirit of the sport.
I don't know. Doesn't that sound, I mean, doesn't the wording sound very broad? Would that really be fair to athletes who, well, after all, if you think about it, they are in an imposed contract, right? To be able to play the game, they do have to sign on to basically this is forced consent. This is my point.
Could you please elaborate on your question?
So, so, so to participate in a game, they are forced in a way to consent to the rules and regulations of the game. And if the rules and regulations of the game are so arbitrary and so broadly worded, then wouldn't that be an issue?
Actually, Mr. President, that that isn't an issue in our case because the rules in our case, while they have to be followed by the while they have to be followed by the athletes in the games that are participating in, they are the ones that are enforced by the courts, and it's up to the courts to ensure that these rules are interpreted and justified. Essentially, the burden doesn't.
Sorry, so if such a rule is so onerous, shouldn't it have been brought to the attention of the athletes?
Mm, understand your concern, Mr. President, and based on the mood problem itself, we do understand that the rules.
I'm sorry, what mood problem?
Sorry, based on the record itself, apologies,
Oh,
Mr. President.
okay.
It was noted at para 33A of GDC's judgment that there was ambiguous signals from
Sorry, hold on, let me get there. You're saying para 33A of the judgment.
sorry, of the record.
33A. Okay, yeah, I'm there.
It was noted that there was ambiguous signals from the event organizers, meaning that there was insufficient notice to athletes. However, it's still important to note the nature of the drug, which is precisely our submissions on this point. And notably, the idea that a drug could simply be formulated without any similar chemical or pharmacological similarity to any drugs inside the WADA code and be consumed by athlete to give himself a ability to be able to perform better than his competitors goes against the very spirit of the sport. And if I could raise a case where such new founded drugs was noted.
But wouldn't you say that the essence of a legal system is certainty in the rules? And certainty, well, I see two problems with it, as you have guessed already. First is the extremely broad wording, and second, the fact that there was, as what you pointed out to me, insufficient notice to athletes.
Yes, Mr. President, but the QGR has already provided that the athletes themselves are also to revert to Rule 7 and 13 of the QGR to find a doping violation under the WADA code. And essentially, there's nothing wrong with the GDC imposing the standard of doping as is essentially the games that's organized by them. And it's not like they have went above and beyond what they're supposed to. Rather, they have also included the WADA code in their rules. It's just that they simply want to find a way to ensure that no doping substances could be consumed by athletes, regardless of the nature of the drug. And essentially, the nature of the drug in our case increases concentration. And the core of it is that as long as a player consumes such a drug, it goes against the very idea that excellence would be rewarded, as that they essentially have a crutch or a way to improve themselves above and beyond their competitors. And notably, this is highlighted in the 2005 US and Belco case, where it was noted, and I quote, "It is impracticable to identify all forms of steroids in a list of prohibited substance, and that restricting prohibition to only certain named substance will be both unfair and detrimental to sport." And this reasoning directly supports GDC's proactive stance in developing Rule 12 to function as a catch-all clause.
Sorry, that was a CAS case, is it?
No, this is a domestic US case, but it has been cited in the CAS book of interpretation, which has been cited by this court before in various CAS
I'm
decisions.
sorry, CAS book of interpretation. Are you referring to an official release by CAS itself, or are you referring to a commentary by some professor?
It's a commentary, but this commentary has been cited before in CAS cases. Unfortunately, I do not have that specific CAS case on hand right now, and I'll defer to my further written submissions on that.
All right, sure.
I note my time, Mr. Arbitrator, unless I may be of further assistance.
How much time do you take?
I have 10 seconds left, Mr. Arbitrator.
Out of 15, is it?
14, Mr. Arbitrator.
14.
I leave 15 for my co-counsel.
Okay. Yeah, thank you.
Thank you, Mr. Arbitrator. This concludes my submissions, and my co-counsel, Mr. Brandon Zhang, will address the further two issues.
Yep.
Good afternoon, members of the panel.
I'm not sure where you are from, but over here is evening.
Oh, yes, good evening, members of the panel. This case concerns Ms. Tangs, who is appealing on the basis that the location of the tribunal being held in South Nankaland is not within the rules, and also concerns Ms. Tangs, who has participated in the games with no genuine connection with Doriana, and in doing so resulted in unfair competition.
So what are you trying to ask this panel to give?
We pray that the panel finds that the game's disciplinary committee did not err in allowing the tribunal to set up in South Nankaland, and we pray that the panel finds that the Ms. Tangs is ineligible to participate in the qualifying games.
So if I decide that in fact the GDC had erred in issues B and C, what are the consequences?
Well, there is an established CAS jurisprudence based on Article R57 of the CAS Code, which I quote, "The panel shall have full power to review the facts and the law," according to which CAS appeal arbitration procedures cures any infringement of the right to be heard or fairly treated. And the panel can rely on many CAS awards in support of this proposition. For instance, in the 2008 CAS case of Andrea Anderson versus the IOC at paragraph 15 through 20, it held that given the authority granted by Article R57, of the CAS code to fully review the facts, the panel considers any infringements are hereby cured and thus irrelevant. As a result, the panel may proceed to rule on the merits of the case. And in the present case, as Mr. Arbitrator had mentioned, if the panel did find the game's disciplinary committee erred, the panel may still be able to proceed on the merits of the case. And if I may direct the panel's attention to paragraph 33 of the record, the game's disciplinary tribunal had viewed her written submissions, the parties' anti-doping reports, and heard parties' oral submissions, and therefore Ms.
I'm
Tang's
sorry, paragraph 30 of the record, is it?
33 of the
Or
record.
33?
And
Okay, go on.
the tribunal there had viewed the written submissions, anti-doping reports, and heard its oral submissions, and therefore Ms. Tangs was able to present her case before the courts, and therefore there has been no breach of natural justice or procedural irregularities, and she was given the opportunity to a fair trial. Therefore, the panel, even if it did find any breaches of natural justice, the panel may still proceed in the proceedings and decide on the merits of the case.
Okay, go
On
on.
the second point, Ms. Tang argues at paragraph 38 of the record that the location of the tribunal was not within the rules. According to Rule 23, Sub 1, an internal tribunal shall be set up for a hearing as soon as possible in the country where practicable to do so. If I may direct the panel's attention to paragraph 25 of the record.
Before you direct me there, I am looking at Rule 23, and the difference between subsection or subrule 1 and 2 is that in subrule 1, it seems like there is a prerequisite before we can enter into this provision. So it says, and I quote, where a party is discontent with the procedure of the qualifying games held, end quote. So are we squarely in the situation where a party is discontent with the procedure of the qualifying games? What is the procedure of the qualifying games?
Mr. Arbitrator, at paragraph 29, it states that she disagreed over the location and that it would not be suitable for her. And on this basis, in the present case, there was a massive riot in the city of
No, that's not what I'm asking, sorry. When I look at the procedure of the qualifying games, are we referring to the rules of the game, or are we referring to the fact that the tribunal has been set up in a certain place? I think there's a difference.
Yes, Mr. Arbitrator. I think Ms. Tang is in dispute about where the location of the tribunal had been set up.
So you refer to that as the procedure of the qualifying games.
I may change the position, the current position. According to Rule 23, Sub Rule 2, the tribunal shall be set up within a week from the end of the tournament, where reasonably practicable to do so. And in the present case, the city was in a 3-day riot and was still cooling off. And given the circumstances of the case, it was a matter of safety to leave the country as soon as possible. And also, this is because, again, there was no way to know how long the riots would last at the time, but more importantly, whether the protesters would start another riot the very next few days within the week. And therefore, Rule 23 sub Rule 2 was not breached. And accordingly, we pray that prayer B be dismissed and the game's disciplinary committee decision be upheld.
How long were the riots for? And yeah, how long were the riots for?
The riots were for 3 days.
3 days.
3 days, but as mentioned, it would still be a matter of safety because it would be unreasonable to hold the tribunal there where there would be a possibility that riots would again occur on the next few days in the same week.
Okay, but I mean, surely we are in a technologically advanced age today. Why couldn't the tribunal just hold an arbitration over Zoom or online? And then you could have done so within a few days and
Yes,
not have, I mean, disregard whatever it is about that's causing the massive riots against the government.
yes. Given the circumstances at the time, it was more practicable to hold the meeting elsewhere where it was more convenient for all of the parties involved, Mr. Arbitrator. And for example, in the global headquarters where it was held was the centerfold of the dispute. And it was the most convenient place because all the relevant parties could be easily contacted through the headquarters. And these parties include the qualifying games medical team, the games committee, and the International Video Games Federation. It was merely more convenient and practicable to hold the meetings in South Nankaland, Mr. Arbitrator.
Okay.
And turning to the second submission, we submit that Ms. Tangs had no close, genuine connection with the country of Doriana in the participating games. And in doing so, this created an unfair advantage for Doriana. And this proposition or this rule is found in the CAS decision of 2010, IFA, Irish Football Association versus Football Association of Ireland, at paragraph 39. The panel, I quote, observed, the cases of players with more than one nationality or who acquired a new nationality who were eligible to play resulted in unfair competition. And thus, in the present case, if I may direct the panel's attention to paragraph 19 of the record, it states that she...
Hold on, let me get there first.
Yes, Mr. Arbitrator.
Okay, I'm there.
Paragraph 19, it states she recently moved over to Doriana. And although she holds dual citizenship, CAS jurisprudence has confirmed there is a distinction between legal citizenship and sport nationality. And the facts of our case are on all fours with the 1999 CAS advisory opinion of International Baseball Association at paragraph 27. The panel said a person may have two or more legal nationalities, but every athlete can only have one sporting nationality. And in the present case, while she does hold two nationalities, essentially she is engaging in what is called nation shopping. And nation shopping has been described as switching between countries in order to take advantage of concepts, to take advantage of personal gains, such as financial gains or prestige from representing their country. And this,
Sorry, Counsel, you said that Miss Tangs had one sports nationality or has two sports nationality. Is that what you're saying?
she has two
She has two.
citizenships, and she is now representing Doriana and therefore switching or acquiring new nationality.
No, sorry. So you first when you spoke about the case earlier, you said that there were two concepts. One is sports nationality, then the other one is legal citizenship, right? Correct me if I misunderstood.
Yes, you are correct, Mr. Arbitrator.
So for Miss Tangs, you are saying that she is uh she's legally citizen of two countries
Countries, yes.
and one sports nationality.
Yes. However, we submit that she has not lived long enough in Doriana to effectively have a sport nationality, and cast jurisprudence recognize that if there's an insufficient period of time of the athlete living in a country after moving to the country, therefore that sport nationality is invalid, and that proposition is found in the 2007
So how long do you need? How long do you need to be in the country?
Well, there's no confirmed years, but in the 2000 and the 1999 case of Mr. Angel Perez, the court held at paragraph 17 that even 5 years in the country prior to gaining 5 years in the country still did not qualify for what was called a sport nationality.
Why? Why did the panel say that in that case?
Well, in that case, Mr. Perez was seeking to represent the USA in a sports competition in that case.
No, I mean, other than the length of time you spend in the country, surely there must be other factors which point to whether somebody has acquired a sporting nationality or not. So can you point me to those factors, and if they are relevant in our case, make the association?
Yes, in the 2007 Melanie Rinaldi versus FINA case at paragraph 36, the panel affirmed that in order for a real change of referring to sport nationality to prevent what was called nation shopping, residents needed to correspond to the center of the athlete's activity in terms of everyday life, training, and competing at a national level for a sufficiently significant period of time to establish that new residence is not fictitious. And in that case, even though Ms. Rinaldi had resided with her grandma in that country of Portugal for significant periods of time, it was still held that those prior times spent in the country was not enough because she had left the country for a few years and then returned. Mr. Arbitrator, I note my time. If there's any further questions, that my submissions.
Sorry, so if you look at paragraph 3 of the record,
Yes.
so it says that Miss Tangs started professionally 2 years ago,
Yes.
and she was a Duriana online streamer,
Yes.
local favorite in Asian tournaments and whatnot.
Yes.
Wouldn't that qualify as 100% Asian?
We submit no, Mr. Arbitrator, because the Rule 3 requires Asian citizenship or permanent residence, but the purpose of the rule was to limit the games to Asian citizens in its Asian stages of the game. And the courts have also have in a long line of cast jurisprudence cases held that it is to give the true intention of the rule maker. And at paragraph 33B of the record, the GDC's decision was that she was not 100% Asian, and this confirms the intention of the qualifying game rule, which is simply for athletes to be 100% an Asian citizen. And we submit that she's not 100% Asian citizen. There are various factors such as residence, dual citizenship, plus a quick, what's called nation shopping that Ms. Tang engaged in.
Okay.
That concludes my submission. Thank you, Mr. Arbitrator, members of the panel.
So what's next? Sorry.
Rebuttal, Mr. President.
Yep.
Thank you, Mr. President. One point in rebuttal. Earlier, you queried the respondent, on the fact that GDC had violated the principles of illegality and due process by imposing such an ominous rule that simply wasn't found.
I didn't say ominous.
Apologies, not ominous, but a rule that wasn't sufficiently clear or predictable in our case.
I think I said onerous actually.
Apologies, Mr. Arbitrator, onerous as it may be, as the principle of legality requires that sanctions are based on clear, accessible, and foreseeable rules. And it was even noted by GDC themselves that the absence of blue bet from its official list, as seen from paragraph 33A of the record, and ambiguous signals from the organizers meant that there was insufficient notice to athletes. By acknowledging themselves that they were unable to impose a rule that could be clearly understood by all athletes, it can't be said that athletes are supposed to follow this rule, as they are insufficiently clear, and an athlete may not be able to understand or appreciate the gravity of committing an infringement against the rules. And therefore, a doping violation cannot be found. Unless I may be of further assistance?
No.
This concludes my rebuttal. Thank you, Mr. President. Mr. President?
Yep.
One point in Sir rebuttal. We note that Rule 12 in itself is considered to be broad, and it may have violated the idea of clear and predictable notice of prohibited conduct. But the main idea is that it was included in the rules themselves. It's clearly stated, Rule 12, the prohibited substance is one that goes against the spirit of the sport. It's not that GDC imposed its own rules or imposed the rule that wasn't mentioned anywhere. It is clearly available for the athlete themselves to look through the rules of the games they are participating in and to look at this provision to ensure that no substance they take would be contrary to the spirit of the sport. And ultimately, there wouldn't be any violation of principles of legality and due process. Unless I may be of further assistance. This concludes my Sir rebuttal. Thank you, Mr. Arbitrator.
Okay.
Okay, yeah. Stop. Okay, go stop.
Oh, how?